And hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and we are here today to learn from our legal news roundup, all the legal news happening in our world, so that you might be better legally informed and understand some things about law, because law is great. It touches everything. It is a culmination of the entire human experience. As I once said, it is the human experience distilled. Every law is a story. Some of those stories have been lost to time, but every law is a story. There once was a guy in conflict with another guy, and there had to be a resolution, and so forth and so on. Add 1,000 years, and presto, bingo, you get the law as you know it today. So I do like the law because I think it is a distillation of the human experience. It is a distillation of our conflicts and the way that we try to resolve our conflicts when we're feeling more intellectual about it. It's a way to resolve our conflicts other than with war, which is nice, right? So instead of let's kill each other, let's our own, each of us, be literally our own executor of justice. Instead of that, how about we come up with a more civilized approach that allows us to come up with an intellectual way of making the law something that we can all understand and appreciate. And thank you, Tony P, right away for the 5 gift memberships. They are extensively appreciated, as is everyone who helps to donate to this channel. All right, so let's go ahead and get started with our legal news roundup. We begin with a lawsuit in California regarding some of the impacts as it relates to student performance or other benchmarks during the pandemic. As you are more than well aware, during the pandemic, the schools were closed. Perhaps this was good, perhaps not, but also perhaps not free, because maybe that online education wasn't as good as the in-person education. This could be due to a lot of reasons. It could be that the education itself wasn't as good because the communication technology, although of course has advanced, isn't quite the same thing as being there in the room. The audio and video quality not necessarily as good, depending particularly on the audio recording device that was used. So some difficulty in understanding the communication and as well as students aren't able to see each other and interact with each other or their teachers, which is particularly potentially impactful to young students who might need that literal FaceTime in order to better socialize. And so there was a lawsuit over this, about the impact of the education as it relates to COVID and not having in-person education. Well, California responded to this lawsuit by, how about we prevent researchers from testifying about these impacts? How about we prevent the people who have done some studies and said, hey, you know, that COVID education with the not in person, that was not free. It led to these potential consequences. Oh no, we don't want to hear from the researchers who might have some information to share on this. We don't want that. Well, California has decided to back down on this policy and might allow the researchers to testify at least somewhat about what they observed, about how COVID impacted children development, child education, and other aspects of and other impacts of the COVID educational policies. Let's go ahead and get started with this. The California Department of Education had tried to block academic researchers from testifying in a lawsuit alleging that the state's school closures damaged academic achievement, but finally backed down. So the school closures, maybe it was good because maybe it reduced the spread of the virus, but at what cost, right? At what cost? The benefits of closing the schools ostensibly is to reduce the spread of the virus. That is the ostensible benefit. Okay, at what cost? And these researchers are like, there were costs. This wasn't a free decision. This wasn't a decision without consequence. And California's all like, nah, we don't want to hear about that. There's been a recent trend in California towards secrecy, restricting the flow of information to media and public about what the officials are doing because, we don't want that discussed because it might make us look bad. A prime example of this was a harsh warning from the Department of Education to education researchers that they could be punished if they testified in any lawsuit against the department. Yeah, so that nice teaching license you have there. Nice job you have teaching at one of our fine schools. Nice job you have. Be ashamed if anything happened to it. You don't want to bite the hand that feeds you, do you? You don't want to testify about how the Department of Education might not be a unilateral, unbounded ball of joy and might have actually made a mistake. You wouldn't want to testify against us, would you? You don't want bad things to happen to you. Yeah, that's about how well it's going in California right now. A clause that was in the researcher's contracts barred the testimony, even if the researcher was not using data obtained from the department. So one of the ways the Department of Education tried to stop this was by stopping in advance. How about you contractually agree that you can't testify against us, regardless of whether the information you used to testify against us was obtained during your employment. So even if somehow you obtained the information on your free time or from non-work related sources, you still can't testify against us because that would be bad, and we don't like that because it might make us look bad. Yeah. The warning, which officials have partially walked back, but not all the way, was issued because the state was being sued by students whose schooling was interrupted and arguably damaged by the shutdowns. Hey, I'm a student. My education has been impacted by these shutdowns. Maybe it helps stop the spread, which is debatable unto itself. But even if it did stop the spread, even if it did do that, it came at consequences. My education was impacted. My social development was impacted. It wasn't the same quality of education. Oh, no. We can't have anything that disrupts the orthodoxy. School closures are good, and there's no negative consequences to doing it whatsoever. Apparently was the idea. Attorneys for the students who wanted to sue sought expert testimony from academic researchers about effects of the shutdown and evidently haphazard efforts to instruct students online in what were known as Zoom schools. The Zoom schools were not the same as in person. The quality of the video wasn't as good. The quality of the audio wasn't as good. It's not the same as being in the room. Anyone who's ever been to any sort of meeting online in any context can testify that it's just not the same as being in the room. Being in the room is a markable difference. There is just no audio, there's no video good enough that's really the same, and particularly not in the kind of audio and video that sort of everyone was using in this time. So, no. Several studies have apparently demonstrated that academic achievement among the 6 million public school students suffered. Maybe there was some academic impact, but we don't want to hear about it. But that achievement gap between the poorer and English learning students and more privileged contemporaries became even wider. So there was already a gap between those who had money and those who didn't. And that gap went up, not down, as a result of technology. As a result of the Zoom schools, at least the way the technology was implemented. So it's not really fair to lay it at the feet of technology itself. That's a bit unfair. But at least the way the technology was implemented in terms of how it was done. So, there was a particular impact among the poor and the disadvantaged. Yeah, okay. For example, a study that California would prefer you not to know about found that before the pandemic, 51% of students met standards in English language, and then that dropped to 47%. Wow, that's like a 10% decrease. That's notable. Maybe you'd like to know about it. Mathematics proficiency dropped from 40% to 33%. Okay, that's like a 15% decrease. All right, that's a lot. Maybe we'd like to know about it. Only 35% of low-income students met state standards, and only 21% were proficient in math, compared to 65% of higher income and 51% with respect to math. So with respect to those of higher income, for English, how about 65 versus 35? With respect to those of higher income versus not, with respect to math, how about 51 versus 21? One will take a note that those are two pretty different numbers. In fact, it's almost like it's exactly half. Just about. It's almost like it's a 2-to-1. That's pretty significant, right? If 65% of the students with the English versus 35%, hey, that's almost exactly half. If 51% versus 20%, 21%, hey, that's almost exactly half. We can't help noticing that the rich students seem to be doing better. So maybe the Zoom is not all it was cracked up to be. There were some problems. Before we didn't notice this gap. Now we've noticed the gap. It's a problem. California, for its part, tended to keep its schools closed longer than other states. So this impact from the lack of video quality, the lack of audio quality, the lack of audio treatment of the rooms, echo, the lack of the ability of the room that the people were listening in, the equipment that they were listening in, and just the inherent weaknesses that are involved in, online meetings of any kind, right? Whatever those impacts were, California was doing more of it. So it was more of a problem because California was doing more of it. And so these impacts, one would imagine, would be higher in California than other states who weren't as dumb. So the loss of the learning as a result of this might be embarrassing to the California government, because the California government's like, oh, we'll close the schools forever. There's no problem. And they're like, whoops, there's a problem. So we don't want to have the embarrassment. Incidentally, by the way, these problems were predictable in advance. And to many degrees were predictable in advance, because the importance of face-to-face education was something that was already known. The importance, particularly for young students, particularly for young children, the importance of being in the room as a method of socializing, being with other people, already known. So these impacts were known in advance, and in many degrees were told and warned of in advance, not that you would notice, of course, because the media was trying to suppress all discussion of that, and California is continuing to try to suppress it. So it's not even like, oh, we didn't know better. Whoops, we didn't know better. We had no reason to believe this would be true. What a weird thing. Now we know for the future. What a whoopsie doopsie. No, we totally knew it, and we totally did it anyway. These were reasonably foreseeable. And now we've gotten exactly what we reasonably foreseed, and now we prefer you not to know about it. We prefer not those who told you and warned you that closing the schools was not a free choice, in the sense that it wasn't a choice that didn't incur cost. And that cost isn't just in form of money. Not all costs are money. Those costs are in education, social development, the ability of the students to perform, and so forth and so on. So it's not free. And now that the bills come due, as it were in this metaphor, the California would prefer not to pay. But yeah, some people might have to tell you about the truth that, yeah, the bill is now due. You have incurred the costs that we told you about, and I know you don't want to know about it, but yeah. When the efforts to muzzle the researchers became known thanks to reporting by the media, because, some of the media did notice and said, hey, we can't help noticing that California is trying to suppress knowledge of this. There was widespread condemnation from the media and free speech advocates because, hey, why aren't these researchers who specialize in exactly this? They specialize in education and educational development. Why don't they tell us in their expertise what impacts they observed? No, we don't want to do it because it's not favorable to what the California government wants? That seems like a problem. Last week, this criticism paid off. The education agency sent letters to researchers saying they could testify about the effects of the school closures, but only if they didn't do with data they obtained through their work. So now at least they can use the external data. So if the only reason you know is from your work, your official work, you still can't tell about that. I suppose that makes sense in some sense, right? It's work for hire. It's information you wouldn't have obtained except through your employment. So we have a right to control the derivative of that, right? We have the right to control the information itself, because this particular information would have only come to your attention because of your job. So we have a right to control the information, and we also have a right to control the derivative of the information. So I suppose that makes sense. But if you learned about it otherwise, if this information is outside of the job, public information, external information, FOIA information, whatever, well, I suppose you can testify about that. That would be fine, they begrudgingly said. The limitations still preclude the recipient's testimony in legal proceedings to the extent it relies on or uses the proprietary data, including its derivatives. So, I guess fair enough, because that's information that you would have only obtained through your employment. So basically, this is a non-disclosure agreement, right? This is information, it's work for hire, it's information you only obtained as a result of your employment. So they have a right to control that information. I suppose makes sense. In a response to a lawyer that was helping the plaintiffs in this case, they say, "We're glad wisdom has prevailed and the state has recognized that the provisions in the partnership agreements are problematic. We regret it took all this legal process to protect the rights of researchers to participate in the public sphere." So it is a semi-victory for freedom of speech in so much as they can use information that they would know or would have come to their attention, but for their employment, right? So if it's information otherwise in the public domain, information from other states, information from other sources, information that they derive some other way, then yeah, you can testify about that. I guess it's okay. The state, of course, for its part, seemingly was trying to bolster its assertion that its handling of the pandemic did not have adverse effects, because that testimony would be really, really bad. What if the people who have access to our data, I bet you really hard that if the data had been more favorable to California, they would have been thrilled for their researchers to testify all about it. Yeah, as it turns out, all those people who said that this would be a detriment to education, they were just flat out wrong. All those people who said, that Zoom would suck and it would hurt the education, they're wrong. We have the data to prove it. Also, we have so much data, and we're more than thrilled for our researchers who are professionals and understand this to testify all about it. So if the data had been, elsewise, I'm sure they would have been thrilled, but, since not so much. So, yeah. No. All right. Thus, that brings us to the end of the case for the moment about California trying to suppress the bad word. California would prefer you not to understand that, closing the schools might have come with some costs. Perhaps it came with benefits. Perhaps it slowed the spread of the pandemic. Perhaps that was a good thing. So the degree to which it had pluses in the plus column is, I suppose, debatable. So what were the advantages of closing the schools? Well, that's a debatable proposition, I suppose. But whatever the advantages are, no matter what the advantages are, there presumably are costs, because very little in this life is free. When you do something, it comes at the cost of something else. Now, maybe it's worth it. Maybe those costs were worth it. Maybe you look at all the pluses and you look at all the minuses and you're like, you know what, California, that was a good decision. I realize it had all these negative effects, but, the positives are so worth it that, it's all good. Or maybe you come to a different conclusion. But California would prefer you not to have the information so that you might not be able to think for yourself. Well, California has changed its mind and decided that, maybe you should have access to the information, and that's where we sit. At least for the moment, that brings us to the end of the discussion of this case. All right, and good morning. Hello, everyone, and welcome to Uncivil Law. I hope you are great. I hope you're having a good day. Thank you, Tony P, again, for the 5 gift memberships. Let me test out my own triggers and see if they work. So we try a new trigger, link tree. Let's see if that works. Does it work? Yep, there you go. So we have the new link tree. I need to make that linkable. I can do that real fast. Hold on. Let me just change that real fast. See, this is why you gotta test these things, because you're like, oh, I should make that linkable. Let's see. Chatbot, chat command, custom command. Change that. Change this. Okay, so this is http:// save. Let's try. Hello, Boosh. Let's try that again. Thank you for telling me to push the button. Appreciate the reminder. Thank you. All right, so now that is linkable. Great. So if you forget the ways to contact me, if you need my post office box, or you forget my other social media, you need a link to the Discord. All those things are now available in the link tree. So if you need a link to the Discord, you need a link to my PO box, you need donation links, you need anything. Now you have the command link tree to remind you about that. Great. Let's try the command donate and see how that works today. Great. So now we have all that too. So I've modified the donate link to provide Zelle, which is just an email address. I don't think that is linkable in principle. So Zelle, PayPal, Venmo, and Stripe, which is all nice in a nice contained box. So if anyone wants to remember how to donate, or like, how can I donate to Uncivil Law? We have the command exclamation mark, or as they say, bang donate. So we have those commands. So those are working. Great. All right. Excellent news. All right. Let's cover another case. In news that hopefully will warm friend of the channel Louis Rossman's heart, right to repair law can now be enforced in Massachusetts as the feds have reversed course. So the state of Massachusetts passed a law that said you have a right to repair. If you own it, you have a right to repair it. And a lot of people were really, really salty about this. And the federal government even was really, really salty about this and said you should ignore the law. They sent a letter saying it was in conflict with federal law. Well, apparently they've reached some sort of understanding now, and the law in Massachusetts is at least allowed to go partially into effect. So let's learn a little bit more about this right to repair law as it now is enforceable in Massachusetts. Let's get started with this. NHTSA, also known as the National Highway Traffic Safety Administration, has said that Massachusetts can go ahead with its right to repair law. Earlier this year, the agency had told automakers to ignore the law, which the voters had passed. So, yeah, they sent out a letter to all the automakers saying, please ignore the law. It's in violation of federal law. Don't do the state law. So, yeah, that was where we are. In June, Senator Elizabeth Warren and Ed Markey wrote to the Secretary of Transportation protesting the advice. So the senators were not thrilled. The agency has said that the rollout of the right to repair law can move forward with some security changes. So there has been some modification to the Massachusetts law. So they've reached some sort of agreement. The law will allow drivers to take their cars to more repair shops instead of just a dealer who used to have exclusive access to some repair data. So now the ability to get access to data in the black box of the computer of your car is now more free. The new law will be expected to bring down the cost of car repairs because now you have your choice of places to go. Because the independent shops can get access to the data, they can repair the car as the data may require. Senators Warren and Markey said that the federal government has heeded our call and clarified the Massachusetts right to repair law can now be enforced, with some minor asterisks. Today's action not only eases burdens and lowers costs for Massachusetts drivers, but also to ensure transportation regulators continue to build on the promise of the Biden administration pro-competition, pro-consumer agenda. Well, we can debate with them on that issue about how Biden is pro-consumer or pro-competition, but, whatever. At least they're letting the law go into effect. NHTSA had said that sharing car data could make it easier for criminals to steal the data or take control of cars remotely, which incidentally, if there is the ability of people to take control of cars remotely, sounds like more of a fundamental problem than right of repair, right? If you have the ability to control a car remotely, yeah, that seems a little much. So maybe the problem isn't the data. Maybe the problem is that anyone can do this, including the manufacturer. Maybe that's a problem. The Alliance for Automotive Innovation filed suit in 2020 to stop the law. Although the case is still working its way through the court, the state said it would begin enforcing the law effective immediately. However, NHTSA had said that that would violate the Federal Vehicle Safety Act. So they're like, okay, there's the federal law dealing with vehicle safety, and if independent shops had access to this data, they might make cars unsafe. So, why should independent shops be allowed to exist? I guess. The Right to Repair Coalition is pleased to see that NHTSA has reevaluated its position and concluded there are multiple ways to implement the right to repair law that don't conflict with the Vehicle Safety Act because, that was really dumb in the first place for the federal government to say that. Really, it was protectionism in the veil of safety. It's like, okay, it's safety because the manufacturer is best positioned to repair cars, so it's a safety issue. Yeah, they tried to say it was a safety issue, but it really wasn't. It really wasn't. It was a protectionism measure, but thankfully, finally, there's been some sort of compromise. So the right to repair law is allowed to go into effect with some modifications. So it's a start in the right direction. I don't think we're necessarily done here as far as these things go, but it's a start. Anything in the right direction is good. So we'll take what we can get for the moment and fight for the rest another day. So good for that for the moment. Thus, that brings us to the end of the case for the moment about the right to repair law that Massachusetts passed, saying, hey, car owner, we can't help noticing cars these days have a lot of computers. And they have these black boxes which record a lot of data. And maybe if independent repair shops had access to that data, they would be in a position to look at the data and then understand what's wrong with the car and be in a better position to repair it. And the dealer's like, no, we don't want that because, safety. Sure, safety is the reason. And then the federal government's also like, yeah, safety. So after some negotiation and after some dithering around, right to repair law is able to go into place with perhaps some modifications. So check out Louis Rossman, who I'm sure will have something to say on the issue as to the degree to which this is a modification or bastardization of the law. But at least it's a step in the right direction, which I suppose is positive in any event. And at least for the moment, that brings us to the end of discussion of this case. Push the button. Yeah, great. Just a friendly reminder, by the way, for all of you out there on the YouTubes, that you can become a member of this channel by hitting that beautiful, beautiful join button. Do you not see a beautiful, beautiful join button? No problem. We also have the command join, which will give you the ability to get the link that you need. It should pop up pretty soon, one would imagine. Hopefully. There it is. Great. Which will give you the link so that you can join for a mere 99 cents a month and help to support the channel financially, because I need your money so I can continue eating. That would be plus. Ask Yaskiza. Ask Yaseka. Ask Yaseka says, waves at Kurt and be fishy. Please check if PayPal worked. Thanks, L'chaim. Well, let's see. Yep, $20. Thank you very much for your kind donation. I appreciate that as well. Thank you very much. That's very, very nice. And anyway, so you can join. And you can also, of course, buy memberships for other people if you like. It should be where the super chat button is. So there's that little $sign under your chat window, presumably. If you hit that $sign, it's how you give super chats. But instead of buying super chats, you can buy memberships for other people. Now, I'd like to clarify this because there is at least one member of my channel who has repeatedly asked me to enable the ability to buy memberships for other people on iOS devices. There's nothing I can do. There is nothing I can do. There is no setting that I have. So this person has said I can buy memberships for other channels from iOS devices. So I can do it for other channels, but I can't do it for your channel. I've asked YouTube about this now twice, and they've said there's no problem on my end. And I posted the conversation between me and YouTube to sort of prove this on my community tab. They say that everything is right on my end. There's nothing to do. So if you are able to buy memberships from an iOS device for other channels, but not this channel, I don't know why. There's no setting that I'm aware of that I can change. YouTube chat has now twice told me there's no setting that I can change. So I don't know what to do. So I just suppose that you're not able to buy gift memberships from iOS for this channel, and that's just the way it is. I don't know why it is the way it is, but it's the way it is. So there's nothing I can do about it. So I'm sorry about that, but that's what we got. Karen Karsten gave 5 gift memberships. Ask Yasiska, who I'm going to pronounce their name differently every time, it seems like, gifted 5 gift memberships. And Wesley Hoke is a member for 2 months. Thank you very, very much. Yeah. Karen says, I just gifted on an iOS device. Okay. So if you were able to do it, Karen, then there's definitely nothing wrong on my, yeah. I mean, I guess I could check it out myself right now that yeah. So can I gift memberships to my own channel? Let's find out. Yeah, so, okay, hold on. Yeah, no problem. I'll just sign into my alternate account real fast. And let's see if I can gift memberships to myself. Okay. Okay. Chat as Blackleaf. Yeah, no, I can't. Let's see. So I can send a membership milestone chat from myself. Thanks to Blackleaf, which is also me, for being a member of 37 months. Blackleaf, you seem like you're a strong supporter of the channel. Thank you very much for your continued presence here. It's very meta. So I can't send gift memberships from iOS. So if you can, you have an ability I don't have, and I don't know why. If I'm a brand channel, it won't allow you to gift or receive gifts. Well, that probably goes well, but my alternate account isn't a brand channel, so I should hypothetically be able to gift from my alternate account because my alternate account isn't a brand channel. But whatever. All right, let's press on. In the issue of homelessness on the streets has gotten so bad that even the San Francisco mayor has given up the ghost, that San Francisco mayor has said they're going to take the inability of them to get the homeless off the street to the U.S. Supreme Court. So right now, the Ninth Circuit, in what seems like quite a strange decision to my mind, says that the government cannot get the homeless off the streets. I mean, it's a little bit more complicated than that, but not by much. Right? It's like if you don't have shelters for them to go to, if you don't have somewhere for them to go to, you have no right to push them off the streets, which doesn't make any sense, by the way, because whether the government has shelters or not, the streets are public property. They belong to the public in a public way for the public, not for any individual person. An individual person can't set up camp because they are literally trying to appropriate a piece of the public for themselves, turn the public into a private, because they're trying to turn it into their exclusive use, which, not so much. Well, this was, the darlings of the progressives. Isn't it so great that the courts say that the homeless can't be forced off the street? And now, years and decades later, even the San Francisco mayor is saying, oh yeah, our inability to force the homeless off the streets is a real problem. We can't help noticing the streets, literally smell like poo. I've been there. They literally smell like poo, and it's a real problem. And so maybe we should be able to force the homeless off the streets. It's nice when even the far left finally gives up the ghost and realizes, yeah, this isn't working. So they finally realize they've made bad choices. Let's learn a little bit more about this. The San Francisco mayor has expressed displeasure about a federal court order that restricts the city's ability to clear homeless encampments. This has been the law for some time. The Ninth Circuit Court of Appeals, in their infinite wisdom, essentially said you can't clear the homeless off the streets unless you have somewhere for them to go. And then, of course, San Francisco can't build places for them to go because of NIMBYism. Everyone's like, not in my backyard. Oh, the homeless should have shelters, but not here, not like that, right? So California and San Francisco in particular have so many regulations when it comes to building new properties, so many things and so many permits and so much red tape that they can't build new homeless shelters. So they can't force them to leave until they have homeless shelters, and they can't build the homeless shelters because everyone, wants to, it's like, we should have more homeless shelters, but not near me and not like that, right? So it's like, okay, well, maybe we should have the ability to clear them off the streets anyway. So the San Francisco mayor finally joining the based and saying, hey, the homeless don't have the right to just be wherever they want anytime. Ask yes says yes, then K. Yes K. Ask yes K. Ask yes K. Why is it hard for me to say? Ask yes. Why is it hard for me to say? Ask yes K. Ask yes K. That's hard for me to say. Does that help? L'chaim membership gifting has always worked for me. Ask yes K. That's hard for me to say. I'll do my best. That's going to take me some effort. It doesn't roll off my tongue, but I'll train my tongue. We'll get there. Okay. The San Francisco mayor is expected to speak at a protest outside the Ninth Circuit Court of Appeals, the same day that city are asking for the federal appellate court to toss out the injunction. How hilarious. The San Francisco mayor is like, oh yeah, it's good. It's good that the homeless are allowed to be wherever they want. Oh wait, no, it's not. And so she's actually going so far as to protest outside the Ninth Circuit Court of Appeals, begging the Ninth Circuit Court of Appeals to reverse its own decision that is preventing this from happening. Members of the Board of Supervisors of San Francisco and residents are also expected to attend the rally. During the meeting of San Francisco's Chamber of Commerce, the mayor said the city has to be able to clear the streets. Wow. When the city of San Francisco's mayors becomes based, it's truly the time for the apocalypse. The San Francisco mayor says, I get that people suffer from mental illness. I get they suffer from addiction. And I know these things are complicated. But if we have a place for people to move, you should not be forced to just allow people to be on the sidewalk. Yeah. On Wednesday, the city attorney will ask a 3-judge panel to invalidate the injunction, which prohibits the city from enforcing specific laws, which I'm not sure the 3-judge panel can do, incidentally, because of the precedent that already exists on this issue. So I think they're going to lose at the 3-judge panel because the judges have already said, the 3-judge panel has already said in the past, basically, you can't do this. So I'm not sure the 3-judge panel has the right to do this. So they'll have to ask the Ninth Circuit for en banc. Or maybe they'll appeal to the Supreme Court and be like, hey, Supreme Court, save us. So the mayor of San Francisco may be going to the U.S. Supreme Court to beg for permission to clear the homelessness off the streets. How very, very based. Fun. The Coalition on Homelessness had sued the city in 2022, accusing city officials of violating federal precedent and illegally destroying unhoused people, that would be the homeless, belongings during encampment sweeps. So yeah, that is the law right now, according to Ninth Circuit. You can't force them to move. You can't take away their property. You can't remove their property from the streets. It's private property, even though it's in a public place. It's private property. You can't remove their things, and that's their home. You can't just remove their things anytime you want. So the Coalition of Homelessness sued the city, saying you're violating federal precedent, which at the moment they are. They are violating the precedent because that's how dumb the Ninth Circuit is. Among other objections, the city argued the injunction conflicts with an earlier settlement that ordered the city to clear encampments near the University of California College of Law, and the courts had insufficiently determined what it means to be involuntarily homeless. How fun. San Francisco getting hoisted on their own fatalities. Only that far-right Supreme Court may help them. And then watch them complain publicly about the Supreme Court deciding in their favor. That will just be the extra cherry on top. They go to the Supreme Court begging for permission to fix their own policies because they can't do it, and then they blame the Supreme Court as the heel. That'll be fun. The Supreme Court mayor plugged the rally for Wednesday morning and asked the business community to also join in the protest. Members of the Harvey Milk LGBTQ plus -2A divided by sign ampersand squiggly mark society and the San Francisco Latinx Democratic Club are organizing an opposing protest that supports the homelessness lawsuit, according to an invitation. So yeah, the left is fighting the left on this issue of the homelessness. So yeah, it's fun times by all. Thus, that brings us to the end of the case for the moment about how San Francisco might be asking the Supreme Court of the United States for permission to clear homeless off their own street because the Ninth Circuit Court of Appeals is so left that they said that the homeless have the right to just occupy public property. They have a right to set up the tent and put out their property in the public, which doesn't make any sense. It's public property. It doesn't belong to any one person. No one person can just take it. Basically they have adversely possessed the public, which is not something incidentally you can do, by the way. Adverse possession doesn't apply to public property, but it does in the Ninth Circuit apparently, because the Ninth Circuit's like you can't force them to leave. If they want to be on the homeless, they want to be there, you can't force them to leave. And they're like, yay, progressivism. And then, fast forward, and they're like, oh no, this is a real problem. We can't allow this. So yeah, the San Francisco mayor is going to the Ninth Circuit, where they'll certainly lose, by the way, because I'm not sure the three-judge panel can rule in their favor. So they're going to lose at the Ninth Circuit. Then I suppose they could ask the Ninth Circuit en banc, but I wouldn't bet them to fix anything. So then we're off to the U.S. Supreme Court. So the U.S. So this and the San Francisco mayor might be begging the U.S. Supreme Court to fix their own liberal backwards policies. How fun! But until that happens, that brings us to the end of discussion of this case. All right, guys, I forget. What am I supposed to do at this stage? I just finished the story. I feel like there's something I'm supposed to do. What is that thing? Does anyone know? Oh, push the button. Oh, okay. That's the right thing to do. Okay. I will train you guys. I will train you guys. I will train you guys. What button am I pushing? I'm pushing the button that changes the background lights, which speaks to your level of observation. I'm pushing the button that changes the background lights. Turn around every now and again and get a little bit. All right. Doesn't it also help with the editing? No, it really doesn't. It should, but no. No. That would be good though, if pushing the button inserted a new timestamp or something. That'd be cool. Don't hear background noises. You're not supposed to. You're not supposed to hear background noise. Why would you? You thought it helped me with editing? It does not. It does not help me with editing, no. Sadly. It is just to change the background lighting so that the stories look a little bit, it's to change the visual of the stories to make them a little bit different. So that when they're posted, they don't all look exactly the same. It's to change the visual appearance. That's it. But that's okay. I love your voice. Did I ever sing professionally? No. With editing, if you can see chat, you could see the end easily. Yeah, no. It helps with the shorts aesthetically, yeah. It helps with the editing aesthetically, yeah. It helps reduce the probability because I changed my shirt. I change my shirt every day, and then I change the background every story. So it helps reduce the probability that someone will think it's the same thing they've already seen before, right? Because then when I post it randomly in terms of the post order. As I said before, my new method of posting stories is my D100, right? Which, not all those numbers are valid because I don't have 100 stories ready to go. But I just keep rolling until I hit a valid number. I think at the moment the top number is 38. So if I wanted to post a story, I'll just keep rolling until I get a number that's between 1 and 38, and that's which story I post that day. Right? So it randomizes things to change up the flow. So You know, it's all behind the scenes. All right. The D1, it's also how I choose which background to use for the shorts, by the way, because there are 30 different backgrounds for the shorts. So I just keep rolling until I get a number between 1 and 30. And that's what background gets on that day. The more you know. I could create more backgrounds, I suppose, so I have 100 backgrounds, but 30 seemed like enough. So sometimes it takes a couple tries to get a valid number, but that's fine. All right. In discrimination on the basis of race is still illegal news, two law firms have sued over programs. Apologize. Let me change that again. In discrimination on the basis of race should be illegal news. Two law firms have been sued over programs they have at their law firms relating to affirmative action. So, law firms, along with other businesses, have for some time had programs in the name of diversity, equity, and inclusion. I liked it better when it was DIE, die, but DEI, whatever. They have programs to help minorities get a leg up in the law firm. Well, that's discrimination on the basis of race, and that's illegal. You can't discriminate on the basis of race; it's illegal. So these two law firms have these programs in place, and after Harvard just got its ass handed to it for the racism, which is discrimination on the basis of race, which you can't do. These law firms are also getting sued for the same thing. Let's get started with this. The American Alliance for Equal Rights, which is a nonprofit whose stated purpose is to challenge race and ethnicity based preferences, otherwise known as the racism, because racism is discrimination on the basis of race, and that's exactly what this is suing some southern US based law offices of two international law firms for their diversity fellowships, which provide advantages for people based on race, which seems pretty illegal. And they're doing this in basis, at least in part, by Harvard, because Harvard shouldn't be able to discriminate on the basis of race. So why should law firms or any other business as well? Because that's also illegal. Because it's a violation of the Civil Rights Act. You're not allowed to discriminate on the basis of race. That's wrong. So you shouldn't have these programs because they're illegal. So yeah. The nonprofit has alleged that the law firm of Morrison and Foerster, which is an international law firm in this case with a Miami office, and Perkins Coie, which is an international law firm in this case with a Dallas office, are both violating the Civil Rights Act of 1866 with their fellowships. That's interesting. The Civil Rights Act of 1866. I'm surprised it's not the Civil Rights Act of 1964, but whatever. Though unnamed, the filing against Perkins Coie mentions an alliance member who identifies as white, non-disabled, heterosexual, first-year male law student who wants to support diversity, equity, and inclusion efforts when he enters in the legal realm, whose filing states he's interested in applying to the fellowship but is harmed by their policy. So this guy just has all the markers against him, right? He's white, he's not disabled, he's straight, he's male. Wow, he's like, I'd like to be able to go into law relating to diversity, equity, and inclusion, but I can't get into the field because you're discriminating against me because I'm white, which is an ultimate irony, right? I want to get into the field of supporting diversity, but you won't let me into because of my race. And around we go. So this person is suing on the basis of these programs are not letting me join. The filing mentions another unnamed member of the association who is also identified as white heterosexual male student who states he's interested in working in the firm's Miami office through a fellowship. These white male students apparently are being discriminated on the basis of their whiteness and maleness, which seems sexist and racist. So that's a problem. Among other forms of relief, the association is calling for an order to stop all the aforementioned fellowships after the requirements to be race neutral and redo applications and fellow selections in a race neutral manner if necessary. So, how about the race neutral? And the law firms, I suppose, will be fighting back. All kinds of fun. It's blurry. Mm, looks okay on my end. Yeah, it looks okay on my end. I'm streaming in 1080 at 30, which is exactly what I want. Yeah, so my video camera is streaming at 1080 at 30, which is exactly what I want. It looks pretty clear. Okay. Thank you. Thank you, Wesley Hoke, for the 50 gift memberships. That is incredibly generous. And because it's 50, that means you get a thanks from Callie. Hi, how are you? My name is Callie. Thank you, Wesley, for the 50 gift memberships. That's really, really thoughtful. Wow. I really appreciate your support and your ability to be an uncivilian. That's really, really thankful. Thank you very much for the 50 gift memberships. I'm Callie. Callie the bee fish. Callie the bee fish. Thank you, Wesley. The Civil Rights Act of 1866, which the people are suing under, was enacted to protect all persons in the United States in their civil rights and furnish the means of vindication. The lawsuit, arguing on the basis of Section 1981, prohibits discrimination on the basis of race, color, ethnicity when making and enforcing contracts. So, yeah. The Wetmore Fellowship had 136 fellows, all of whom had been rewarded with $25,000 stipends. So they just get $25,000 for free, which is kind of nice. At Perkins Coie, Diversity Fellowships received a paid summer associate and also $15,000 stipend each year they participated in the fellowship and a $10,000 award if they worked for the firm upon graduating law school. So you get a paid summer position, which is a pretty big deal. $15,000 in addition to the paid summer position, which is nice. And if you wind up working for the firm, they'll give you an additional $10,000, which is also nice. It's just free money. So this is just free money in addition to whatever salary you would otherwise get. Both of the members that are suing cite prestige of the law firm and monetary payments of fellowships as reason for wanting to apply, as filing state they are interested in gaining work experience and money to help them pay for expenses. Yep, pretty much. Has the live chat now finally just stopped completely? Did the live chat crash, or just no one have any comments? I guess. All right. All right, there we go. The lawsuit comes after the Supreme Court outlawed affirmative action or race as a factor in college admissions because that was literally racism. Discrimination on the basis of race is wrong. This case was provoked by the lawsuit from Students for Fair Admission against the universities of North Carolina and Harvard. This particular association member in this case formerly attended an Ivy League college, though the filing doesn't specify which one, because for the moment they're trying to proceed anonymously, which I'm not sure the courts will allow, but they're trying to for the moment. Thus, that brings us to the end of the discussion for the moment about the two law firms being sued over their own diversity initiatives because they're only really available to people of certain races, which is pretty racist. It's discrimination on the basis of race. It's literally prejudicing someone based on race, which seems pretty racist. And the Alliance for Equal Rights, the American Alliance for Equal Rights over here is like, you just ruled this was illegal in education because, of course it is, because, it's unconstitutional and illegal. And here they're citing they're citing the Civil Rights Act, which is like, yeah, it's illegal. You can't discriminate on the basis of race. So, yeah. So the two law firms are perhaps the first among many private entities to be sued for the racism. So these initiatives perhaps coming to an end as we realize once again that racism is bad. And that for the moment brings us to end of discussion of this case. Push the button. Yeah. All right. Gritty Gret and Allison Grunnell get credit for a button. All right. In the question of what kind of dog can be emotional support dog, there is a question in New Jersey, as the condo association doesn't want to allow dog to be in the apartment because it says the dog is too heavy. The dog weighs too many pounds, and this is a problem. So we don't want to allow emotional support dog because emotional support dog is too big. I guess emotional support dogs have to be smaller. And if they're bigger, then not so much. So can this person bring their emotional support dog into their New Jersey condo? Let's learn a little bit more about this. This case surrounds Luna. Luna is a 70-pound shelter pup that probably doesn't know that they're at the center of a fight that's climbed to the New Jersey High Court in a case that could remake the rules as it relates to emotional support animals in the state. Luna's case is in the hand of the state Supreme Court nearly 5 years after the black Labrador mix was adopted as an emotional support dog by a couple living at Camden County Condo Complex, which is a very hard name to say. Camden County Condo Complex. Might want to work on that name a little bit, just saying. This particular complex forbids any pets that are over 30 pounds. So it's like, if it's a pet, not more than 30 pounds. 30 pounds is our limit for pets, apparently. But the couple refused to get rid of Luna, saying, it's not a pet, it's an emotional support animal. So when they refused to get rid of Luna, the condo board took them to court, presumably by trying to evict them. And so now we're at the New Jersey Supreme Court on an eviction proceeding, which, fine. The lower court judge signed with the dog's owners, and the appeal court found that, that the dog's owners are right. But the appellate judges were split, and they decided to appeal again, and the New Jersey Supreme Court decided to have review. So can dog live at condo? Dog 70 pounds, limit 30 pounds, but it's an emotional support dog. So maybe that matters. Okay. All right. The appellate judge, writing in the dissenting opinion, said that Luna may be a good dog, and we'll take note here that the judge did not make a finding that dog is good dog. So who's a good dog? Luna might be a good dog. We're not sure. That doesn't bark, but those characteristics do not give defendant the right to carve out an exception to the association's lawful and enforceable rules and regulations regarding pet ownership. How fun. So, you don't have a right to insist that the entire association bend for you, says the dissenting judge. In the Court of Appeals case, the question before the Supreme Court is whether the condo board must make an exception as a reasonable accommodation under New Jersey's version of a law against discrimination. So this is all going to be New Jersey specific, right? Because emotional support animals, I don't believe, are supported by federal law. Although someone could double check me on that. I don't know that there's any federal law about emotional support animals. Like for the Americans with Disability Act, for a seeing eye dog, yes. But for emotional support dog, I'm going to go with not so much under federal law. So I'm pretty sure this is being driven by state-specific law. So state-specific law apparently says, emotional support animals, I guess. And this is a question as to whether or not this is a reasonable accommodation or not. So that's the question. Is this a reasonable accommodation or an unreasonable accommodation? The decision could change the balance of power between housing providers and tenants and residents as it relates to the restrictions of support animals. The number of service and support animals across the country has grown in recent years because people were like, aha, I have the right to an emotional support animal, then I can have any kind of animal I want. So people claiming that things are emotional support animals because you don't necessarily need to show any particular documentation, because what is an emotional support animal other than one that gives me emotional support? Who is a good dog? They're a good dog. They love me. Also, good lizard. Also, good dragon. Does anyone have a dragon I could keep as a pet? Because I'm totally down for keeping a dragon in my apartment. So if anyone has a pet dragon they could lend my way, let me know, and I'm more than willing to say that's an emotional support dragon. I will give it a hoard of gold to guard. I'll give it some treasure to guard, and it will love me, and hopefully not breathe fire on me. It'll be great. The number of service animals have grown, so too have legal disputes over the rights of human beings, often playing out in the quasi-governmental arena of local condo boards. So a bunch of Karens carrying this thing all over the place. No baby meatball, not that. Bad baby meatball, bad. State civil rights officials have gone after landlords and housing boards that have denied accommodations for support animals through enforcement actions, but only with some success. In 2019, the State Division of Civil Rights reached a $20,000 settlement with a co-op board after they denied a tenant's daughter's permission to get an emotional support dog after her father's death. In 2020, the agency fined a pair of landlords thousands of dollars in two similar cases. Just last month, state authorities announced 3 enforcement actions alleging housing providers violated anti-discrimination law by unlawfully denying tenant or prospective tenant initial request to live with an emotional support animal. Nationwide, there are apparently 116,000 emotional support animals that have been registered with the National Service Animal Registry, but rules governing who can get one and how one can get is complicated, not for least of reasons that this is being primarily driven by various state laws. Jennifer Perry, who's an access specialist for Northeast ADA Center, said federal disability and housing law treats assistance animals different from pets with highlight protection for their owners. Assistance animals include both highly trained service dogs with specialized skills and support animals. As to that part, I'm not so sure. Under federal law, I don't know about that, but that's what they think at least. New Jersey law takes its cue from federal law, but offers even broader protections for those deemed handicapped. I would imagine, New Jersey wants to be super progressive, and then amazingly, people are trying to abuse it because that's how this goes. An attorney for the condo board did not immediately return a message seeking comment. Thus, that brings us to the end of the case, dealing with the New Jersey Supreme Court, dealing with the issue of emotional support dogs as it operates under state law as it relates to a person who claims a disability by needing the emotional support dog. I mean, I need an emotional support dog. People often in chat tell me I should get an emotional support dog. They say you should get a dog, and then it will make you happy. Maybe it will. Maybe I need an emotional support dog. But can I get an emotional support dog in my life? Probably not in Texas. But in New Jersey, they say you can. They say you can get an emotional support dog, but whether or not you can get 70-pound emotional support dog, yet to be decided. So that's what's going on, at least for the moment. That brings us to the end of discussion of this case. Jingleberry and Baby Meatball say push the button. We will push the button. Yeah. All right. I do have an emotional support bee fish. That's true. Emotional support bee fish is a good emotional support animal. It doesn't require anything. It just gives endless love. It always has a smile on its face. Emotional support beef fish is good beef fish. Okay. In Can We Give Tickets to People Who Are Homeless for, just what would be the term? Loitering. That was the word I was wanting. Couldn't quite get there fast enough. In Can We Give Tickets to People for Loitering if they're homeless news, the city of Oregon, a city in Oregon rather, is asking the U.S. Supreme Court to weigh in on the question of whether giving tickets to people for loitering is cruel and unusual punishment if the person is homeless. So a person who is a private person has tried to overtake a public space and is remaining there in trying to claim the space in a private way. The public space necessarily belongs to the public in a public way, not to any individual person. So if a person is just standing around loitering, vagrancy, then maybe we can give them a ticket. Or can we? Because maybe that ticket is cruel and unusual punishment. So let's learn a little bit more about this dispute coming from Oregon. Let's get started with this. A city in Oregon is asking the U.S. Supreme Court on Tuesday to decide whether local governments may ticket homeless people sleeping on public property or whether that's cruel and unusual punishment that violates the Constitution, which, no, it's not. I don't think so. Not given the guidelines on cruel and unusual punishment. Cruel and unusual punishment is kind of difficult, actually, in sort of a legal sense. You have to go quite far for it to be cruel and unusual. So you could probably put people in jail. In fact, I know for sure you could put people in jail, for being homeless, or more the point, for vagrancy and loitering, right? It's only when you start talking about really long sentences or really high fines that you're even approaching the idea of cruel and unusual. But, but basic stuff, no. Grants Pass, which is a city of 38,000 in Southern Oregon, told the Supreme Court in an appeal that prohibition on handing out tickets has created a dire situation within the encampments of homeless people, which hamstrings officials' abilities to deal with crime, fires, and the re-emergence of medieval diseases. Because amazingly, these people are not necessarily keeping themselves in the best condition. And so we've got, all kinds of problems. So Grant Pass is over here like, we want to give out the tickets for loitering and vagrancy, but they say we can't. And so we're not able to deal with this problem. The question of whether people without homes can be punished under laws designed to regulate public camping and sleeping outside has been percolating in federal courts for years as several states and grapple with the burgeoning homelessness. The U.S. Supreme Court declined to hear a similar case in 2019 after a federal appeals court in California ruled that homeless Americans could not face criminal prosecution. So the U.S. Supreme Court previously decided not to hear a case, but of course, the balance and interest of the court is always up in air. And I think they might have a different view this time around. So, At issue in the case in Oregon is a ruling from the Ninth Circuit Court of Appeals, which has held that cities could not issue tickets to homeless people who are using blankets, pillows, or means to protect themselves from the elements. The court noted that cities handed out dozens of citations every year, sometimes with fines that reached several $100s. So it's like, okay, you can't punish the homeless for just living on the streets, even though they are taking up part of the public for private use. They are using the public in a private way, thus depriving the public of the ability to use the public in a public way. They are literally commandeering the public. But the Ninth Circuit Court of Appeals is all over here like, nah, we don't see any problem with that, fam. And San Francisco is also seeing some problems with this as well. The number of homeless people outnumbers the number of available shelter beds, the court had wrote. In other words, In other words, homeless persons share no have have. They didn't put a space in there. I'm sorry, I couldn't read it. In other words, homeless people have nowhere to shelter and sleep in the city other than the streets or in parks. The anti camping ordinances prohibit plans from engaging in activity they cannot avoid, which isn't the right analysis, by the way. That is not the right analysis, right? The public property belongs to the public in a public way. The government can't interfere with you, but they don't necessarily have to help you, right? So if you want to buy private property, if you want to use private property, the government can't necessarily stop you, but you don't have any right to commandeer public property. The fact you have nowhere else to go is not necessarily the public's problem. The public isn't necessarily even required to give homeless shelters at all. Like there isn't a constitutional right to that. But the Ninth Circuit over here is like there is. So, okay. In a sharp dissent, the U.S. Circuit Judge had wrote the appeal court effectively guarantees a personal federal constitutional right for individuals to camp or sleep in sidewalks, parks, playgrounds, and other public places in defiance of traditional health, safety, and welfare laws, and also in defiance of what it means for public property to be public rather than private. So, yeah, that's what the Ninth Circuit said. There's nowhere for these people to go, so you can't make living on the streets illegal. But you totally can, because that property belongs to the public. Find somewhere else to go. I have nowhere else to go. Well, as they say, that is not my problem, that you have nowhere else to go. That is not my problem. I am not preventing you from going somewhere else, but you are not allowed to use my property because it belongs to the public at large, not for you. The Eighth Amendment to the Constitution, of course, bars cruel and unusual punishment. The number of homeless people living in this particular town ranges somewhere between 50 to 600. The Supreme Court may decide whether to hear this particular case later this year or in early 2024. So, yeah, I don't know whether or not this particular case will get to the U.S. Supreme Court or not, but one of these cases is going to get to the Supreme Court, I think, eventually. And I think the Supreme Court is going to whack the Ninth Circuit around and be like, public property belongs to the public in a public way for public use. And no particular person has a right to commandeer it for their own personal use, no matter what the circumstances are. So if the public wants to say what the limitations of using it are, they can. Because it's for everyone's collective benefit, not for any individual person. Which seems like the right analysis. And if you want to jail people for it, you can. If you want to fine them, you can. Yes, you can. You can also commandeer their property because it's being kept on public property. So if they put up a tent, you can seize the tent because it's on public property. And so you're just maintaining your own property at that point, right? So yes, all that's legal. But the U.S. Supreme Court is going to have to take up one of these cases because the Ninth Circuit's not going to do it. All right. Thus, that brings us to the end of this case in a city in Oregon, which would like the ability to ticket people in its city, but the Ninth Circuit Court of Appeals has said, no, you can't do that because the homeless have nowhere to go. And of course, you can't build new homeless shelters because no one will let you, right? You can't build it because of NIMBYism and all the restrictions and properties. You want to build a homeless shelter, every single person has to have, their own individual suite, where it's not good enough. So, and you can't build it here, no matter what you can do. So, yeah, the city of Oregon has asked the U.S. Supreme Court to review this decision from the Ninth Circuit. I'm not sure whether or not they'll take this particular case, but they'll take one of them. And the U.S. Supreme Court is going to rule that public property belongs to the public in a public way, and no particular person has a right to commandeer it. And if you leave your personal property on the public property, the government has a right to seize it because you can't keep it there. So eventually the U.S. Supreme Court is going to reach that decision. And at least for the moment, that brings to the end of discussion of this case. Did someone say push the button? Oh my God. Did it change? Push the button. Push the button. There you go. All right. Was that what book is that? What book is it where they wrote, the majesty of the law is that it bars both the rich and poor from sleeping under bridges? Was that Les Mis? Was that Kurt Vonnegut? Uh, was that which book was that? Damn it. Damn it. I'm having a literature moment. Anatole, France. Anatoly, France. The law, in its majestic equality, forbids the rich as well as the poor to sleep under bridges, to beg in the streets, and to steal bread. Anatoly, France. And where did he write it? Damn it. God damn it. The Red Lily? He wrote that in the Red Lily, 1894? Okay. Well, Anatoly France apparently wrote that in 1894 in a book called The Red Lily. In its majestic equality, the law forbids the rich and poor alike to sleep under bridges, to beg in the streets, and steal loaves of bread. I thought maybe it was. I thought it was Les Mis. Okay, well, it was Anatoly France. All right. Well, we've clarified our quote confusion for the day. All right, let's move on. All right. In true crime news, a woman has been arrested for allegedly injecting some kind of substance into the neck of a random Walmart customer. So that people of Walmart thing, man, wow. It's real. Apparently, we've just got a woman just walking around with a needle in hand, just injecting things into people's necks. Okay, that's a lot. Let's learn a little bit more about this case. Two people allegedly fought the cops after one of the suspects stuck a syringe into a customer at Walmart. It's going just that well over here. Cops show up. They're starting to fight the cops. It's going great. Jennifer Keenan, who is 55, is charged with aggravated battery, possession of a firearm or knife during commission of a crime, and willful obstruction. Jay Carswell, who is 73, is charged with obstruction. According to police documents, officer responded to the Walmart in Duluth, Georgia on August 10th. Security had said that a man had come to customer service saying that a woman who was wearing a yellow plaid shirt stabbed him in the neck with a needle and injected him with some foreign substance. If you're Walmart security and a guy comes up to you and be's like, this woman in the yellow plaid injected me in the neck with a needle, how do you respond to that? How do you respond to that? Do you even believe it? How do you even respond to that? I don't know. But apparently this person called the police. Because like, well, one way or another, I'm out. So they called the police. When the police arrived, security pointed out the suspect's vehicle, which was a blue Ford Expedition parked at the side of the building. So apparently security, watching where this woman was going, the woman in the yellow plaid, said, okay, the woman in the yellow plaid is in that blue Ford Explorer. Okay, the police would like to have a clarifying word. Police approached the man in the driver's seat. They said it was Carswell. When asked if he was alone, he said no, and that his friend was in the back seat. The person in the back seat was Keenan, according to officers. She stepped out when asked. Carswell gave his driver's license. Keenan refused to give up her information, documents said. Then the situation escalated. Police say they pulled her arms behind her back to handcuff her because, they do have a report from somebody who says this woman injected me with a needle, which, is report of a crime. So, they're going to try. So it looks like the police are taking this seriously for the moment. So they're like, okay, we're going to detain you, at least for the moment, as we try to figure out what the hell is going on, because we have a report of, a serious felony. So, we're going to detain you while we investigate this. Apparently, it didn't go well. As she stepped out of her vehicle, an officer pulled out a taser and told him to get back in the vehicle. So the guy stepping out to try to interfere. Caldwell began yelling while returning to the vehicle, police said, and the woman apparently was resisting. While still watching the male suspect, I overheard Officer Holliday state he was in an active fight with the female suspect due to her getting out of one of the handcuffs. She is not thrilled with being in the handcuffs, so they weren't able to get them all the way on. When he gained back control of the female suspect's arm, the officer yelled the female had a gun on her person. The other officer grabbed a gun. Keenan allegedly yelled for Carswell to help her. So things are not going well in this tussle in the Walmart parking lot. The woman has a gun. She's resisting arrest. She's fighting the officer's assault. It's not going great. I observed the male suspect moving around the vehicle, and it was at that moment I lost sight of his right hand due to him reaching for something, which at this point would get the police's attention right up, right? If you already believe the woman has a gun, and now you see the guy reaching into his pocket for something, well, things are not going great. I then gave him numerous verbal commands to show him his hands. When the male suspect started to move his right arm to reach for something, I immediately ordered him to exit out of the vehicle. He allegedly stepped out of the vehicle, but then re-entered it in spite of the officer's demands to get on the grounds with his hand up. Yep. At that moment, I then opened the car door in an attempt to gain control of the suspect, the police said. It was then the suspect closed the door with his left hand and tried to start the vehicle ignition to drive off. The officer used his stun gun, and the suspect reached into the backseat to grab at something else. It's amazing at this point the suspect hasn't gotten shot. Okay? At this point, it's amazing the suspect hasn't gotten shot. You're resisting arrest. You're reaching all over things. Your other suspect has a gun. It's amazing that you haven't gotten shot. Another officer who used a patrol vehicle to block him from fleeing stepped forward to help pull him out of the vehicle. In one report, officers found a gun in the man's right pocket. Oh, he was reaching for a gun. And 3 fully loaded shotguns in the backseat of the vehicle. Oh, that was what we were reaching for. Oh, so when we saw him reaching into a pocket, it was for a loaded gun. Oh, when we saw him reaching into the backseat for something, it was for one of 3 fully loaded shotguns. It's amazing this guy isn't dead. It is not going great. The other officer reportedly described 2 rifles and a shotgun in addition to the gun personally possessed. The individuals remain locked up in the Gwinnett County Jail, apparently only on $3,500 bond, which, holy God, why is it that low? At this point. But yeah, that's where we are. So we've gone from suspect apparently injecting something into someone's neck and fighting the police and all kinds of shit. This is going to be an interesting trial, to be sure, on a whole number of levels. Thus, that brings us to the end of the case of Jennifer Keenan and Jay Caldwell, pictured here, two individuals who are definitely people of Walmart in every possible sense. Apparently, the woman was going around and just injecting people in their neck with some unknown substance, which, would get my attention right up. And apparently, both of them are fighting, and they have guns. They both have guns on their person and guns in the car. So, yeah, something is really, really odd here in Georgia. So, we will figure out what's going on with all that, and that, for the moment, brings us to the end of discussion of this story. All right. All right. In Hey, What's in This Drink news, Florida woman is accused of spiking people's drinks with roach spray. So that funny taste you've got in your drink is not in your imagination. Apparently, it is roach spray. That is what we like to spike people's drinks with. That is how we're rolling in Florida. Okay, let's learn a little bit more about Florida woman with the roach spray. Let's get started with this. Florida woman is facing charges after allegedly poisoning a man by adding Raid's roach spray to his drinks. Not a recommended drink for the craft concoctions at your local speakeasy. The incident unfolded at the residence of Wheeler Street in DeLawn Springs, Florida. Authorities from the local sheriff's office responded to a distress call around 4:30 in the morning. Upon arrival, they encountered the victim, who was later taken nearby to a hospital for medical treatment. According to law enforcement, the victim detailed to deputies that the woman had returned home from a bar outing and urged him to join her for more drinks at their residence. Well, that's a nice thought, I've been out for an evening of drinking, but I'd like to share a last drink with you. But apparently, it was intended as a very last drink, I guess. The victim disclosed that he had consumed 2 beverages and subsequently began feeling ill. It was during this time that he reported that apparently the woman reportedly confessed to adding Raid roach spray to his last 2 drinks. So, I don't feel very well, honey. These drinks aren't sitting well with me. Oh, it's because I added Raid roach spray to your drinks. Wait, what? I don't know what bar you went to. I don't know what mixologist you talked to. But Raid roach spray, not one of the recommended drinks. If you don't have the Angostura bitters, handy for your old fashioned, Raid roach spray is not a good substitute. I'm just going to tell you right now. The victim recounted to deputies they endured apparently a half hour of vomiting before managing to seek help. Even as he was providing his statements to the deputy, he was struck by more illness. So as he's reporting to this cop, he's like, I need to throw up some more. It's going super, super well. At the time of the deputy's arrival, the woman was not found within the residence. However, a canine unit was dispatched and successfully traced her to a location nearby. So she had left the apartment, but she didn't go very far. The woman was subsequently transported to the branch jail, where she's apparently being held without bond. Her initial court appearance remains pending to charges against relating to the act of poisoning food or drink, and also perhaps attempted murder, aggravated battery, and some other charges. So where this will stop and where it will end, who knows? But it's not going well. Don't use the Raid roach spray as a drink. That's not in compliance with the labeling instructions, I'm pretty sure. Thus, that brings us to the end of discussion of Florida woman who apparently thought that Raid roach spray was best addition to a cocktail. You know, I watch Legal Vices sometimes, and he does many different drinks. He does many different drink recommendations and drink recipe things. He likes the drink recipes. But I'm not sure Legal Vices has ever thought of the possibility of using Raid roach spray as an addition, which speaks ill of Legal Vices. He doesn't have a good imagination. If only he had the imagination of Florida woman, he would know the truth that Raid roach spray is best addition to the cocktail, apparently. Or so she thinks, I guess. So we'll see how that all progresses. And at least for the moment, that brings us to the end of discussion of this story. Yeah. Legal Vices is on right now. I could redirect you over there, and you could harass him about not using Raid roach spray. Let's see who else is streaming. Let's see. Who's streaming that I want to send you over that way? Let's take a look. Let's say Legal Vices is streaming. I'll send you over that way. He's giving a redo or giving a redux on his time visiting us, so you can ask him questions about what he thought about Uncivil Law. Ask him questions about what it was like to meet me in person. Ask him questions about his time. Ask him questions about all those things. I'll send you over over Legal Vices way, so you can go hang out with him for a while. I've been Uncivil Law. Until later, my friends. I hope all is well. Cheers, my friends, and have a great day. Goodbye.